Webinar time, live from Lockdown City. I'm Chris Hynes, Strata consultant, former Commissioner of Body Corporate Community Management. With me, also in lockdown as always, Frank Higginson, Hynes Legal partner. Frank, welcome.
Hello everyone, and Chris, I'm going to correct you first up. I'm actually in quarantine. I'm one
Goodness,
better than
too.
lockdown. I can't leave the house. Neither can any of my family, and we're still okay. No one's killed anyone yet, but we've still got another week and a bit to go.
Yeah. I think the Chief Health Officer said something like 8,000 people in home quarantine at the moment.
Yeah.
Goodness me.
Yeah.
Anyway, for everybody watching us today, hope you're all doing okay, staying as healthy and as sane as you possibly can. We hope we can give you half an hour of, well, call it entertainment, information at the very least. Don't forget, if you've got any questions or any comments, you can chuck them into the live chat today. And link going up just now where you can direct a question to us after the event. That's probably a good link to use if your question's a bit involved, because it's difficult for us to answer a really complicated question in this format. But give it a go, and then we'll have a go, because that way we'll get a go.
You sound like ScoMo then.
Yeah. Anyway, with that, today, where on earth do owners go wrong? And Frank, we are equal opportunity finger pointers, aren't we?
We are. We are mercenary in that sense. We will point fingers at anyone for anyone. But I suppose, in a sense, I suppose it's a question of framing, isn't it? Sort of, it's framed a little bit negatively in terms of where owners go wrong. But as always, between the two of us, it's sort of really, I suppose, some of the behaviours, we've done this for body corporate managers, we've done this for resident managers, so it's now, we don't have a committee one specifically, I don't think so.
No, probably not specifically. All right, that goes on the list.
Part 4. I think the next one then is for lot owners in terms of some of the more common bad behaviours we see, and then probably how to, I suppose, for everyone to probably get past that. So some of these things are, in a sense, it's difficult for participants in the strata industry to say to someone, hey mate, hang on, you're not doing this. So in a sense, that's what these webinars are for. In one sense, it's like, here's a mirror, go have a good hard look at it.
And I think that the really positive message, Frank, to take out of today is that we don't think there are that many, if any, situations which are not retrievable somehow. It might take a bit of work to retrieve, but generally speaking, even if something has gone wrong in your role as a lot owner, and then from the other side as well, generally speaking, you can bring it back. Yep, definitely. I reckon, Frank, the place where it all goes wrong in the first place is that an owner becomes part of the body corporate, no questions asked, no choices given. Pretty much you buy your lot, you go on the title, and that's it. You're in the body corporate. You don't get out until you sell or till you die.
Yeah, it's sort of like Thunderdome, except no one leaves. So yeah, and that it's one of the things. And I suppose, ladies and gentlemen, Chris and I were 2 weeks ago, Strata Title Working Group, and that's talking about legislative reform. And one of the topics on that agenda is disclosure. So what should prospective buyers be given before they buy into a piece of strata real estate? And one of the issues that absolutely was live in that room was, how do you actually get people to read when they're buying the dream? So it quite often, and everyone's had these stories, people finish up, they're sold the dream by the real estate agent, because that's what agents are good at. They suddenly end up owning a piece of real estate, and hang on a minute, what's this body corporate thing? And that's where it starts. It's not a house. You are bound by another set of rules, which is what these things are really all about. And I suppose, Chris, we've got codes of conduct for resident letting agents, for caretaking, service contractors, for body corporate managers, for committees. There's not one for lot owners though, is there?
There's not. Arguably, you can say that bylaws are their own code of conduct, kind of. Should there be a code of conduct for owners? I reckon, why not? Something I'd be interested in everyone's thoughts on watching this. Should there be a code of conduct for owners? Should there be any kind of minimum standards, or other than the fact that you've bought a lot, for owners? interested to hear everyone's thoughts on that one. But ultimately, Frank, you get what you give. And if you're an owner and you're going to behave poorly, well, you can expect things to go badly, can't you?
You can. If you start whacking people with sticks, it's a bit unreasonable or unrealistic in a sense not to get whacked with sticks back.
Definitely. Definitely. Well, with that, why don't we rip right into it? So Frank and I are going to rattle off all of the, well, not all, but most of the ways in which we have seen owners go wrong over the journey. So I think it's our combined years of, I don't know, expertise.
See misbehaviour?
Yeah.
Whichever way you want to put it.
Yeah, close up. So we might take this in turns. I'll kick it off. So first way, being pig-headed. Being only interested in your own outcomes. Now, I get it. 100%, I get it. You've got to prioritize yourself and your lot as an owner, of course. You can't lose sight of the bigger picture. And the bigger picture is you're part of a bigger entity than just you. Yeah. You can't, yeah. Sorry, Frank, go.
I was going to say, if there's a horse in the race called self-interest, you back it every single time. But in strata communities, it's not just about that at times, because the difficulty is that everyone has got a horse in the race. So if you've got 50 lots, you've got 50 lot owners, you've got 50 people that might have different opinions, different needs, different wants. And if it's all about you, then potentially that's not necessarily going to work.
That's right.
Particularly if you're in a minority.
You've got to also have your eyes on the prize of the fact that there's a longer term game in a body corporate. Decisions that you make now might take years, literally, to come to fruition. And you've got to realize that if you follow that through to its logical extreme, it can only be a good thing for you as a lot owner. Anyway, that's that one. Frank, your turn.
And mate, even that, we had a judgment handed down today where we acted for a body corporate dispute that had its genesis 4 years ago. And we won, which is good, but there you go. Court's a lottery, but leave that aside. So next thing, probably, from a owner's perspective, one of the worst things you can be is ill-informed, uninformed, or misinformed, I suppose, would be the three types of information. And the difficulty that we have with this is that, let's start with the positive. Queensland, the Commissioner's Office, the best information resource you can actually get other than us. You can ring them, you can ask them questions, they will answer them. You can send them emails and they'll come back to you. So there's really, in a sense, less of an excuse to be ill-informed in strata in Queensland than there is anywhere else with that type of resource. But the amount of people that go off half-cocked, I got told this, I saw this, the Act says this, I saw this on social media, without any reference point at all to what the issue actually is extraordinary. And that in itself creates half the fights. You're wrong, mate. Well, no, you're wrong. And then someone rings the Commissioner's Office, gives them a set of facts, and the Commissioner's Office responds with an answer to that set of facts. And then they turn around and say, well, the Commissioner's Office said. And it's like, well, what did you tell them? So it's that, and again, it's a little bit subjective, of course, Chris, because we're in the business of supplying advice in relation to these particular issues, but it is complicated. It's designed for self-governance, designed for people to find their own way through it, but it's bloody difficult.
It is difficult. I like to refrain from commenting on social media, but when there are comments about body corporate issues, I can't help myself. And so they actually come up in some of the local groups, community groups I'm part of. They come up a lot, and someone will ask a body corporate question, and there's an immediate pile on from every person in that group offering all sorts of answers. About 99% of them are often wrong. And then I can't help myself. I leap in and I give an answer. And I always temper it by saying, look, I know a little bit about body corporate law, and but Frank, don't pay any attention. It's easy enough to click and figure out who that person is. So anyway, I think your point is really well made about the cesspit, which is social media. If that's where you're going to take your body corporate expertise from, it's going to go bad every single time. Next one, not appreciating that you're part of a bigger picture. Oh no, sorry, I've jumped ahead one. I'll take that one. You take the next one before it, Frank. Not seeing that you're part of the bigger picture or the long-term future. And I touched upon this one a little bit before. So today you're voting on improvements to the driveway or improvements to the pool, and you're being asked to pay a fair whack of money to get that done. And you, of course, are going to say, but that's so much money, and when am I going to see the benefit of that? I can't afford that. But think about it in 2 years' time when the work is done and how schmick and gleaming it's all going to look. And imagine just the value that adds to the property. Imagine how that's going to look in the marketing pictures when you put your lot up for sale, as opposed to an undeveloped, unrepaired, and not terribly attractive looking thing. The bottom line is, you've got to think about the end game that happens a bit later on. Frank, over to you.
Yeah, and it's interesting. I've got I think there is an opportunity to help bodies' corporate strategic plan. I really do, because this sort of piecemeal committees turn over every year, and that's the legislative framework. That's what we've got. That's okay. But in terms of where is the building going in 10 years? And I suppose I've got a lawyer mate that is on his committee, and he's trying to actually now have that 10-year plan for his building, including the likely prospects for committee membership to come through over a period of time. So it'll be really interesting to see how he goes, but that's not a traditional approach in bodies corporate. So eye on the prize, but what is the prize? Absolutely. So I suppose, and part of that then is also people not appreciating they're actually part of a community. Again, this is this nebulous body corporate relationship that you are bound to by law when you actually own a lot in a scheme. You're part of the decision-making process, and you're part of that body corporate community. So same thing, say to clients all the time in body corporate, particularly with management rights. Management rights is sort of next level community because you're usually a resident there, but you've also got a contract to provide services to the body corporate and potentially to lot owners in the letting side of things. So you're wearing a couple of different hats. But just in a pure lot owner to lot owner sense, if you don't like what Chris and I say today, you unsubscribe, you block us on Facebook or wherever else you might see us, and you never have to see us again. Never happens. Happy days. We're out of your life. In a body corporate context, you cannot do that. You are part of that community while you actually own a lot. So like it or not, if your email address is on the records, people are going to be able to access it. If you go to meetings, there's going to be other people there who might or might not like you, and vice versa. So I think for me, it's that and mate, social media again, that ability to throw stones from behind a keyboard, not necessarily anonymously in these ones, because you can have building groups and those sort of things, but throwing stones at people via emails becomes a completely different proposition when you've actually got to go and meet with them face to face. And I suppose, Chris, back to Commissioner's office, if you're going to have a body corporate dispute, 99 times out of 100, that's going to finish in conciliation before you go to adjudication. And that means you're going to be sitting down opposite or in a room with the person you're having the fight with. So as a lot owner, you've got to remember that you are tied to the hip to a degree with the other lot owners. So in that sense, it doesn't make a whole lot of sense to act out early and pick fights. You are part of a community that you can't get away from.
That's right. The next one, not understanding that there are limits to what you do or do not need to be involved with. And the best way I can sum that up is that just because something occurs within a body corporate does not mean it is up to the body corporate to resolve it. Good examples of that are some behavioural issues that take place. Just because they're occurring in a body corporate does not mean it's up to body corporate laws or body corporate bylaws to resolve those things. Another good example is you're not entitled automatically to know what your neighbour is up to all the time. You're not entitled either to know what the rent roll is like of the on-site manager in the building. So just because it's happening within the confines of that body corporate does not make it either a body corporate issue, nor does it make it your business as a lot owner. So know where the limits are. A couple of questions have just been chucked up there. We will get to those. Thank you. Keep them coming if you are watching. Frank, over to you.
And mate, I'd say the interesting thing, like, you know, lockdown we're in at the moment, new health directions. There's a bit of a messy health direction around pools in terms of residents being able to use it, non-residents or short-term people not being able to use it in one interpretation. Is that a body corporate issue or is that a police issue?
The body,
yeah. Exactly. So it's that sort of stuff. Next thing, I suppose, and this is probably, referencing some of the things I've mentioned before, behaving aggressively. We see a lot of that. And the best bit of advice, same bit of advice I give lawyers, new lawyers when they're starting with us, particularly younger lawyers, everything you write, you've got to write remembering that in 2 years' time, that might be in front of a judge. And if you write everything with that in mind, you'll temper a hell of a lot of what you punch out, particularly late at night, particularly when you're angry, and particularly when you're responding to something that's just needled you, and don't wait the 24-hour rule. So that just sort of passive aggressive behaviour, outright aggressive behaviour, is just not conducive to good body corporate relationships and actually problem solving and remaining part of the community that you are bound to.
Doesn't mean you have to be friends, but going aggressive, particularly going aggressive straight away, yeah, that's a surefire way to put things offside. Next, and I think you've already alluded to this one a little bit, Frank, is engaging in email warfare. If you're going to sit there and hit reply all and include in the CC line every owner and the body corporate manager and the caretaker, as well for good measure your local MP, the Prime Minister and the Queen, and send 20 of those per day, very, very quickly, things are going to go off the rails if they're not already well and truly off the rails. Email is great. It's immediate. It's a good way of communicating. We don't have to rely upon carrier pigeons or snail mail or anything like that. But email definitely has its downsides. And one of those downsides is that you can just type anything out in an instant, hit reply, and you feel satisfied without necessarily having taken the time to think about what it all means. We're not saying don't communicate via email. We're saying be strategic about how you use your email. And the same old things that we have talked about 50 trillion times in the past, not hitting reply all every time, putting it in drafts, getting somebody to do a tone check on it as well.
Next one, not participating. It's very hard to criticise body corporate decisions at committee or general meeting level when you haven't bothered to participate in the first place. It's that simple. You want to get involved, you want to throw stones, then get involved and be part of the process. Because the hardest thing, not the hardest thing in the world, from an adjudication perspective, is if you're going to challenge a body corporate decision at general meeting and you haven't voted, it's not a good look.
Well, it won't pass go, Frank. The first, if you are challenging a general meeting decision in my former office, the first thing you are likely to be asked is, did you vote? And if your answer is no, then yeah, it won't be going very far at all. Look, let this. You don't have to do anything. There's no compulsory voting in a body corporate, so let's keep that in mind. You can sit there for however long you own the lot and not do a thing. Your choice, but I think you lose the right to complain afterwards if that's how it works out. You absolutely don't have any right to complain if you don't participate. Now, Frank, we are running out of, because we want to get to the actual positive bit of today, which is how you actually make this better. And oddly enough, we've got to stack more things where people go wrong. Do we want to hold those over for a part 2?
Yeah.
Yeah,
because it's solutions. I mean, we can sit here and throw stones probably for another hour if we feel like it. And sorry, everyone, but you know, I think probably of the remaining things, I think probably more than anything else, mate, it was really the next one on the list, is not paying attention. If everyone thinks that everyone else is doing the job, then no one's potentially doing the job, and that's also bad. So from a lot owner's perspective, you've spent who knows how many $100,000 buying your investment. Keep an eye on it. Read the budgets, read the minutes, read the motions, see what's going on. Don't rely on other people to do what is effectively your job. Because again, if you do that, then potentially you're not necessarily going to get the outcome you want.
That's right. So yeah, we have a stack more of instances where owners go wrong, but we're going to save that for a part 2. And there's also plenty of solutions we can do in a part 2. Before we get to today's solutions, might address a couple of the questions that have popped up. Lucy, thanks for tuning in. Can an owner who is annoying, bullying, troublemaker be banned from running on a committee? No. In a word, no. There are other ways in which they will be ineligible, for example, if they haven't paid. But no, you can't ban them for those reasons. Neil, Can bylaws be written and enforced which contradict or lessen the local council laws? I.e., if a contradiction exists, do the council laws and penalties always take precedence?
I suppose you've got two conflicting systems there, don't you? You've got the council regulations which require X, Y, and Z. Then you've got the body corporate bylaws, which might be something different. So they can be inconsistent. They absolutely can be.
The legislation, Neil, actually says if a bylaw is inconsistent with another act. So you'd have to contextualise it as being inconsistent. So if we're talking about a council law, what you're really asking there, is it inconsistent with another act? My understanding is council laws are made under an act. Well, I thought so anyway. Frank, you may know better than me. So I would think that they would be inconsistent, but don't quote us on that one, Neil. We might have to come back.
Well, and I think probably the easy example might be council says you can't start renovation works before 7 a.m. and the bylaws say you can start at 6. If it's in the bylaws, it doesn't mean you can start at 6.
Yeah, that's a good way of thinking of it, Frank. Mark, thanks for tuning in. How do you have some input when you attend a meeting but are unable to speak when committee in session? Good question. So when you're attending a committee meeting, you've got to understand that owners do not have an automatic as of right to attend every single committee meeting. And if they do, they certainly don't have any right to talk and participate as they might like to. There are restrictions on committee meeting participation. As an owner, you have input at a general meeting. That's where your level of input comes in. And you also get to speak at those committee meetings at certain times. So you take advantage of that and you exercise your vote at general meeting. And of course, Mark, the third way, put your hand up to be on the committee or turf out the committee that you don't like. And Gleno, regular, thank you for tuning in. How about the ramifications of not voting on motions that are obviously not supported by legislation? Good question, that one.
Like, mate, to me, that's abstain or vote no, and you can even indicate your reasons. Like I literally had a phone call with a client 2 hours ago. EGM today, invalid resolutions. Frank, I want to challenge it. What do I do? I said, put your concerns on record, vote no. There's a record of why you voted no, and that's going to preserve your right to go to adjudication in 3 months after the meeting. So go to the meeting. If your motion gets defeated, happy days. If it gets up, then we've got the rights to challenge it.
But yeah, you don't not vote. All right, let's focus on some positives. So when owner's gone wrong, how do they recover? Well, look, some of these things may sound like a bit of an oversimplification, but we reckon it gets boiled down to these. This first one's yours, Frank, so you take it away.
I like this, and this is probably the story of Strata. I had a client years ago said to me, we learn all of life's important rules in kindergarten. You play nicely in the sandpit with the other kids, you share your toys, and you don't call each other names. If we all followed those rules back at the start, we'd probably be in a much better strata space. But I just had to throw that in, Chris. But in terms of actual solutions, I suppose this is your AA line, really, isn't it?
It is. So the first solution, give yourself over to that higher power, I reckon. So admit it. And if you're going to admit it to no one other than yourself, that's fine. But admit that you were wrong and that you need to get better informed. So if you don't want to admit to the other people on the committee that you were wrong, okay, don't do that. Admit it to yourself, though. Acknowledge that that was a misstep and you could have handled that situation better. Learn from the experience. Next one, Frank.
And that really means taking, to acknowledge that you might have done it incorrectly, you've got to educate yourself. So you've got to take advantage of the information and assistance that's actually out there, either on a paid basis with us or an unpaid basis with the Commissioner's office, websites, whatever it might be, to help you understand that you might have gone off half-cocked.
The next one, stop making assumptions and start actually getting advice and start knowing things for sure. The number of times, Frank, we see it, people just assuming they know what the answer is and ploughing on without having verified their knowledge of it. It's a really dangerous thing to do in this context.
Yeah, it is. And it's probably a lot of the lot owners we act for come to us with assumptions about what's going on. I need help with this, and here's what it is. It's like, well, a lot of the times, mate, it's actually not that. It's this. So if you've got to come back to this is where you need your help. It's almost like a Dr. Google type thing. You Googled, you've got a cough and you think you've got COVID. No, it's not quite that simple. So it's that assessment part. People, and that's back to again, those assumptions and misinformation before, they charge off down a track that's actually not the right track.
That's right. Participate as much as you can under the circumstances. So if time does not permit you to sit on the committee, okay, that's understandable. Find other ways to get involved. Perhaps there are options for somebody else to pay attention on your behalf. Read the minutes, read the agenda, read the paper. There are plenty of ways to be involved within the limits of the time that you have available. And I reckon the final one, the most important one that often gets lost, and it defies belief how often this point gets lost, your end game is a financial end game. Every time it's your asset. But your asset isn't just your lot, is it, Frank?
No, the scheme as a whole. It's the whole of the thing, you know, and it's that people do read body corporate records, they do read commissioners' office decisions, they can see things are going wrong. So if you know, that eye on the prize is a really important part, I think, of lot ownership. It's not that sort of, and sometimes I get it, can't see the forest for the trees, you're in the midst of whatever this particular issue is. And to be fair, some of the issues that we get involved fighting over aren't really material in any major way to that end prize. So there's that little bit of, and this is it. As Chris said years ago, and I'm not going to, or steal his line yet again, is we're never ever going to be able to regulate human behaviour. So as much as we've got all this wonderful legislative stuff, human behaviour is what it is, and we're never going to regulate that to the extent that we won't stop these issues. But these things, what we're trying to do with these webinars is help people probably, hopefully, step back sometimes and get away from some of them.
That's right. So look, we can assist you with all of those things. That's what we do day in, day out. One of the areas that might be interesting, we've talked a little bit in the past, Frank, about challenging person facilitation. So we're just putting up the link to some of those webinars that we've done on that topic that were very popular. That might be an option in this particular situation from both sides, maybe.
Yeah, committees, lot owners or otherwise, because then don't get me wrong, sometimes committees can be just as crazy as anyone else and drive lot owners to distraction. So again, it's just people. But,
that's right.
And what we're really about is trying to help people understand the issues and get to the bottom of it without having to engage in trench warfare and lawyers at 10 paces. That might be the only option. But it
might mean spending a bit of money now to save yourself spending a whole lot more money later on. That's what we mean by not being short-sighted about things. And look, Frank, we get it, don't we? It's not easy, and it's not cheap. We don't work for free. But look, one of the takeaways, I think one of the things that I would really like people to take away out of today is, so often it happens in our world, doesn't it, Frank, where people get trapped in that endless cycle of asking about where do they stand? What are my rights? How often do we hear that said on a day-to-day basis? What are my rights? Where do I stand? As an owner, well and good to find out what your rights are, and well and good to find out where you stand. But if you're not willing to do anything with it, what's the point of that?
Move on.
Okay.
Absolutely move on.
So if you're going to find out where you stand, and if you're going to know what your rights are, you have to be prepared to take the next step and do something with those rights and to do something. Because, yeah, it's pointless knowing where you stand if all you're going to do is stand there. It doesn't work. So I guess the wrap up of all of that today is that, and if it's seeming like we're picking on owners, remember we're not. We've picked on everybody else as well. We'll probably have a session about where strata lawyers go wrong at some point, and also where former commissioners go wrong as well. God, that'll go for hours, that one. So we're not picking on owners. We're trying to help. The way we help is by identifying where it goes wrong first so that you can then rectify the behaviour. So obviously there's a bit of interest in this one, so I reckon stay tuned for a part 2, which won't be too far away.
No. And so next week, I'm on my own.
Well, at this stage.
Let's see, if Chris might not be travelling, subject to what happens with lockdown restrictions and border controls and all the rest of it, I'm going to do some management rights stuff. So one of the misconceptions, biggest misconceptions we get in management rights is the difference between options and variations what they are, how they work, what you have to do with respect to them, and so on. So we do a lot of that type of work. So it's really a 101. So if you're interested in management rights and how those agreements work, then this time next week will be for you.
It's actually really a good one too for committees and owners, Frank, that one, because when this mysterious thing called a top-up comes your way, you've got to have some concept of what it's all about. So we'll go into those details next week. But for now, thanks everybody, some great engagement today. I hope that, again, everybody out there is staying safe, not going too crazy. Hopefully by the time we next see you, we might be out and about a bit more. Especially you, Frank.
Oh, no, I'm still Friday night, midnight.
No, that's exciting.
I'm still in this house for the next week.
Okay, maybe not. All right, with that, everybody, Frank, thanks very much.
Thank you, everyone. Thanks, Chris.
Thanks
Bye.
all. See ya.